We are standing on the unceded territory of the Musqueam people, territory that extends well beyond UBC, particularly many sites along the Fraser River, if you don't know them. In a way that segues well into David Boyd, who I first met when he was coming to UBC to do a PhD thesis on environmental justice or injustice in Canada, and turned out the data wasn't great on that. And guess what? It still isn't great. So we should be entirely suspicious about that fact. But moving on from there, David's the only person I've ever known who came to UBC with a dissertation already done in the form of a book that he forgot to list on his many books that's known as Unnatural Law. So it's the comprehensive book on the state of environmental law in Canada at that time. But then has gone on to use his
time's up, Terry.
No, sorry. His very good empirical brain on many things, and his passion for the capacity for constitutional environmental rights and international environmental rights, and the right to healthy environment in particular. So, and we have the luck of having in our very presence also David's role as the special rapporteur for the UN on human rights and the environment, and that's what he's going to talk to us about today. But frankly, you could talk to us about all kinds of things. So welcome, David.
Thank you. Thank you, Terry, for the, as always, too kind introduction. And it's a great honor to be here, as you said, on unceded Musqueam territory. The land acknowledgement always makes me think, well, are we paying rent yet? Yeah, so it's nice to talk about it, but we should actually be doing something about it as well. We've got a short time and I'd like to try and accomplish 3 objectives. One is to give you all an update on what's happening in the world of the right to a healthy environment, your right to live in a healthy environment. 2, to kind of demystify what is a UN Special Rapporteur on Human Rights and the Environment, and ideally, over the course of this 50 minutes that we have together, stoke the fires of hope. So that's a tall order, but we'll give it our best shot. It's also fortuitous that we're here today, and it is the 75th anniversary of the Universal Declaration on Human Rights, which began in Article 1. The drafters came up with these inspiring words: all men are born free and equal in rights and dignity. But fortunately, there was a woman from India at the conference where the Universal Declaration was being developed, a woman by the name of Hansa Mehta, who was a teacher and advocate. And she said, what? All men? And so she managed to persuade the drafters to change the wording to all human beings are born free and equal in rights and dignity. So I think that's an interesting kind of anecdote about the power of an individual who's passionate about human rights. And of course, written in 1948, there is a glaring omission from the Universal Declaration, which is it does not include the right to a clean, healthy, and sustainable environment. That has been the objective pursued by civil society organizations around the world for decades, dating back to the 1990s. And on Friday, October the 8th, 2021, on the left at the United Nations Human Rights Council, the right to a healthy environment was finally recognized by the United Nations. It was an incredible roller coaster journey to get there. Thousands of people who influenced this outcome. But even 5 minutes before the vote, the ambassador from Slovenia walked behind me and said, "It's not looking very good, David." And I kind of like had my heart in my throat. And over behind me, the ambassador from the UK and the ambassador from Brazil were having a very heated conversation. Russia introduced 10 last-minute amendments that would have eviscerated the motion or the resolution to recognize the universal human right to a healthy environment. But the first sign that things were going to go well in terms of the vote was that those 10 amendments were overwhelmingly rejected. And when the president of the Human Rights Council, a good friend of mine from Fiji, called for the vote, you could hear a pin drop, and then the screens at the front of the human rights room just went in a sea of green, which is states voting in favor of the resolution. And the final score was 43 votes in favor, 0 against, and 4 abstentions. Unfortunate that it wasn't a resolution by consensus, but China, India, Japan, and Russia abstained. And then, of course, the Human Rights Council is a subsidiary body of the United Nations General Assembly, so the campaign kind of had to be redone in New York, and that led on July 29th of last year to the adoption of a resolution by the General Assembly led by the ambassador from Costa Rica, Maritza Chan, who's an amazing woman. And that passed, or that was adopted with 161 votes in favor, 0 against, and 7 abstentions. So again, an overwhelming vote in favor of UN recognition of the fundamental human right to a healthy environment. And a question people always ask me is, well, what difference do these UN resolutions make? And it's probably too early to say what the resolution on the right to a healthy environment will make in terms of a difference. So I want to talk about the UN resolution from 2010, recognizing the universal human right to water. That was 2010. A few months after that resolution, I saw a story in the Winnipeg Free Press, which really shocked me and made me angry. And it was a story about thousands of people, in fact, tens of thousands of people living on reserves in northern Manitoba without running water. And these images from the newspaper of people going to the lake and digging a hole in the ice and then filling buckets and jerry cans to bring back to their homes, where they didn't have toilets, they didn't have any running water at all. It really, I had known there were problems with drinking water on reserves in Canada, but I didn't really grasp it until I saw these pictures in the newspaper. It made me angry. And what can academics do to vent their anger? I wrote an article called No Taps, No Toilets, where I basically made the legal argument that Indigenous people have a right to water, a right that's based on Section 7 of the Canadian Charter of Rights and Freedoms, which is the right to life, liberty, and security of the person, Section 15 of the Charter, which is the right to equality, an obscure provision in Canada's Constitution that says all Canadians are entitled to essential services of reasonable quality, and also those Canadian legal rights buttressed by international human rights law in the aftermath of the UN resolution. So that kind of made me feel a bit better, that venting process. This was published in the McGill Law Journal in 2011. And over the ensuing years, I kept getting contacted by law firms in various parts of the country wanting to talk about this. And eventually, a class action lawsuit was filed on behalf of 3 First Nations, one of the First Nations in northern Manitoba and 2 in northern Ontario, arguing basically, if you looked at the originating notice of claim, taking these arguments, putting them into a lawsuit against the government of Canada and seeking $2.1 billion in compensation for having suffered, in some cases, for decades without access to safe drinking water. And so that was really exciting to learn about that class action lawsuit. But even more exciting was to learn in 2021 that this class action lawsuit had been settled for $8 billion. $2 billion in damages that's allocated to 142 First Nations and individuals who lived on reserves without access to safe drinking water, and $6 billion that will be invested in drinking water infrastructure and wastewater treatment infrastructure over the next 7 years. So from now till 2030, the government is obliged to spend that. The government also agreed to bring in legislation that will be co-developed with First Nations to create standards for drinking water in Indigenous communities. So this is really a landmark class action settlement in Canada. The lawyers representing the Indigenous communities were paid $53 million. And I'm sad to report that none of that found its way to me. So the government of Canada is actually making progress finally. Since 2016, 138 Indigenous communities have gained access to safe drinking water. There's still another roughly 30 to go, so the job's not done. But we are making progress, and I think that it connects back to the recognition of those rights. And when the right to water was recognized by the General Assembly in 2010, that was a catalyst for action around the world. So countries like Costa Rica, Fiji, Mexico, Slovenia, Tunisia added the right to water to their constitutions, their highest and strongest laws. And in Mexico, they then put in place a policy to bring safe drinking water to rural communities, which has reached hundreds of rural communities over the past decade. This is a photograph taken last year on a UN mission to Slovenia, one of the countries that did add the right to water to their constitution. And I was shocked to visit a small Roma community in Slovenia, and this is their source of drinking water, basically a muddy pond beside a small stream. And I wrote about this in my report to the United Nations on Slovenia's record in respecting human rights. The government of Slovenia wasn't very happy with me, but last week in Geneva, in responding to my report at the Human Rights Council, they made a commitment to deal with this problem within the next 12 months. So there's another example of the rights-based approach making a difference. So now, enough about the right to water. I want to talk about the right to a healthy environment. What is the right to a healthy environment? Well, although these UN resolutions are very recent in 2021 and 2022, there are countries around the world that have decades of experience with the right to a healthy environment. Slovenia included it in their constitution in 1974, Portugal 1976, Spain 1978. African nations, when they agreed upon the African Charter on Human and People's Rights in 1981, included the right to a healthy environment. So over 4 decades, we have this experience around the world where there are now more than 150 countries that recognize the right to a healthy environment in law, either in their constitutions or legislation or through these regional human rights treaties. And my predecessor as the Special Rapporteur, Professor John Knox, did a tremendous amount of work on the procedural aspects of the right to a healthy environment. That is the right of access to environmental information, the public's right to participate in environmental decision-making, and access to justice with effective remedies when your right is being threatened or violated. When I came aboard in 2018, I really wanted to turn my focus to the substantive elements of the right to a healthy environment. And so I did a series of 6 reports to the Human Rights Council and the General Assembly, looking at clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments, healthy ecosystems and biodiversity, and a safe, livable climate. And I drew those elements from the decades of experience, from government legislation, from government policies, from court decisions at the national and regional level. So there's a ton of history to these substantive elements. And what I want to spend the bulk of my time with you this afternoon is talking about the way that this rights-based approach really has transformative potential and transformative value. I don't know if some of you were here several years ago when Professor Paul Slovic did a talk which had the terrible title, "The More Who Die, the Less We Care," but basically making this argument that human brains are not numbers oriented. So I've been saying for years, 7 million people die every year from air pollution. Why isn't that a public priority? Nobody seems to care when you say that. But this beautiful, vivacious child, her name is Ella Kissy DeBraw. She grew up in a polluted part of London, England, outside the famous low emissions zone in central London, where all the wealthy people live. They have terrible air quality outside that ultra low emission zone. And she developed asthma at the age of 7, which really put a cramp in her life because she loved dancing, she loved swimming, she wanted to be a pilot, but her asthma got progressively worse. Her mom had to take her to hospital 27 times. And on the 28th visit, they were unable to resuscitate her. So her mom, whom I've gotten to know over the past few years, Rosamond, was a teacher, but had no idea that there was a connection between air pollution and her daughter's illness until in the aftermath of her death, she read something in a newspaper about the connection between air pollution and asthma and was absolutely livid that her daughter was taken from her. And so she campaigned to have a coroner's inquest into her daughter's death. Rosamond quit her job as a teacher and became a full-time advocate for clean air and the right to breathe clean air. And eventually she did convince the government to have a coroner's inquest. And the death certificate for Ella Kissy DeBraw is the first in the world that identifies air pollution as one of the causes of death. And so this beautiful face is emblematic of the need to recognize people's right to breathe clean air. And so I've been supporting Rosamond's campaign for something called Ella's Law, which is a law that would require the UK government to recognize the right to breathe clean air as a human right and create standards, air quality standards, that are consistent with the World Health Organization's most recent guidelines published in 2021. Because of Rosamond Kissy DeBraw, this has actually been passed through the House of Lords and is now at second reading in the House of Commons. So this is actually a bill that has a chance of becoming law in the UK, which is really incredible. This is a picture from a community in South Africa called Mpumalanga. which has some of the worst air quality on Earth. There are 12 coal-fired power plants in this community, coal mines, and a monstrous facility that transforms coal into liquid vehicle fuels. And two very courageous environmental justice organizations filed a lawsuit in 2018 against the government of South Africa, arguing that the failure to improve air quality in Mpumalanga is a violation of the constitutional right to live in a healthy environment. They reached out to me after I became the special rapporteur and asked if I would support them in this lawsuit. I wholeheartedly jumped in and filed what's called an amicus curiae brief, or a friend of the court brief, which is basically articulating the international human rights principles that apply in this case. Last March, the court reached its decision and agreed with the environmental justice organizations that the government's failure to bring in regulations to improve air quality in Mpumalanga violated the citizens' constitutional right to a healthy environment. The court gave South Africa 1 year to bring in those regulations. That deadline expires on Friday of this week. So looking forward to seeing what happens there. A similar case in Jakarta, Indonesia. Again, oops, that's still in Mpumalanga. There's Jakarta. Jakarta, Indonesia, some of the worst urban air quality in the world. And again, citizens hired a lawyer, brought a lawsuit based on their constitutional right to a healthy environment. And last year, again, well, actually 2 years ago, I filed an amicus brief in this proceeding. And again, the case was successful. The government was ordered to take action to improve air quality. The government appealed that decision. The Court of Appeal, again, upheld that as a violation of the constitutional right to a healthy environment. And there's an organization in Europe called Client Earth that has brought literally dozens of lawsuits arguing that governments' inadequate actions to improve air quality in countries including France, Germany, Belgium, Poland, and other European nations violates people's right to clean air. Now, there isn't actually a right to clean air in the European legal system, but they've been using the European Air Quality Directive to make that argument and using this as kind of their public campaign. And they have been incredibly successful, as I said, in dozens of lawsuits. So that's on the first element of the right to a healthy environment, about air quality being part of it. I've talked about the right to water earlier, but of course, safe and sufficient water and healthy aquatic ecosystems is also part of the right to a healthy environment. This is a photograph taken in Buenos Aires, Argentina, of the Riachuelo River, which was the subject of a lawsuit that went to the Supreme Court of Argentina in 2008. Again, citizens arguing that pollution was violating their right to a healthy environment. The Supreme Court of Argentina agreed and ordered the federal, municipal, and provincial governments to undertake a series of very bold actions to transform this heavily polluted watershed. So the governments have spent literally billions of dollars building drinking water treatment infrastructure, wastewater treatment infrastructure, creating a solid waste management zone. They dredged literally tons of metal and scrap garbage out of the river. They took away, basically the banks of the river were lined with corrugated metal shacks. They took those down and built social housing for the people who were previously living there. And the results speak for themselves in terms of the improvement of environmental quality in the Riachuelo River. The same year, actually, 2008, there was a decision by the Supreme Court of the Philippines in a case brought by a maverick environmental lawyer named Tony Oposa. And again, the Supreme Court of the Philippines ruled that pollution in Manila Bay violated the constitutional right to a healthy environment, ordered the government to take action to clean up Manila Bay. Now, you can't clean up a place like Manila Bay or the Riachuelo River overnight. There's such chronic pollution and so many sources. But a principle from human rights law comes into play, which is the principle of maximum available resources. Governments have a human rights obligation to invest the maximum available resources in fulfilling their human rights obligations. And so in Argentina, as I said, the governments in Argentina have spent close to $3 billion over the past 15 years in the restoration of that watershed. In the Philippines, which is a less wealthy country, the government is progressing, but at a slower rate. Another element of the right to a healthy environment is the right to live in a non-toxic environment. This is, it's amazing what you can see on Google Earth these days. So this is a photo of a coltan mine in the Democratic Republic of Congo. To illustrate this aspect of the right to a healthy environment, I produced a report on what are called sacrifice zones around the world. Really a kind of horrible phrase that comes from Chile, where sacrifice zones are places where corporate profit and private interests are being prioritized over human health, human rights, and the environment. And my report highlighted is the wrong word, but my report lowlighted, if you will, over 50 of these sacrifice zones in every region of the world. And what's the encouraging thing about this is governments don't like being targeted with that language of sacrifice zone. So I'll just share a few examples of where there has been tangible progress over the past year in sacrifice zones. So Kabwe, Zambia is the site of a long-standing lead mine and smelter that was operated by a British company for decades, has poisoned children for decades with lead poisoning. And just within the last few weeks, the government of Zambia has announced a green Kabwe initiative where they're planning to decontaminate the land and create a series of parks and protected areas, playgrounds for children. The jury's still out on can they deliver, but it's actually an encouraging sign. This is a photograph from a community in Chile called Quintero Puchuncaví, where there's an agglomeration of industrial facilities, coal-fired power plants, chemical factories. And in 2018, there was an air pollution incident that resulted in hundreds of school children being hospitalized because of exposure to contaminated air. That resulted in a series of lawsuits that went to the Supreme Court of Chile and decisions that ordered the government to take action to address this horrific situation. And so there have already been several of those industrial facilities that have closed down. I'm going to Chile on a country mission in May, and I'm certainly going to do a visit to Quintero Puchuncaví and see what's going on there on the ground. This is the Atoyac River in Mexico. The color of this river looks odd in the photograph. That's because of chemicals that have been discharged into the Atoyac River, and obviously having an impact on aquatic life and people who rely on this river for drinking water, for fish, and other elements. And so this case has been the subject of a petition to the Inter-American Commission on Human Rights, which has ordered the government of Mexico to declare it as an environmental emergency zone and take steps to protect people's health and well-being. These images are from one of the most unbelievable places on earth, which is a place in Louisiana nicknamed Cancer Alley. Probably the most intense concentration of industrial facilities anywhere in the world. And the United States Environmental Protection Agency under President Biden has made environmental justice one of their top priorities. There's actually a bill before a bill in the US Congress called Environmental Justice for All Act, which, if it was passed, would recognize the right of Americans to live in a healthy environment. Because of Republican control of the House, that's not likely to happen. But just 2 weeks ago, the United States Environmental Protection Agency announced that it is suing a Japanese company for elevated levels of emissions of a chemical called chloroprene. Chloroprene concentrations in St. James Parish, because of this single industrial facility, were 8,000 times higher than the US EPA limit. And so finally, the government there is taking action. This is an electronic waste recycling center in Agbogbloshie, Ghana. And they're just burning electronic waste to get rid of the plastic and get the valuable metals that are underneath. This is now the subject of a European Union funded cleanup campaign. A colleague of mine just visited Agbogbloshie and said that there's still a lot of work to do, but at least they're moving in the right direction. Another human rights principle which comes into play when governments recognize the right to a healthy environment is something called non-regression, which means that today's standards create a floor below which governments cannot go. They cannot go backwards. And so, of course, we saw the kind of terrible policies in the Brazilian Amazon under President Bolsonaro. The previous president, well, 2 presidents earlier, President Lula da Silva, had actually brought in policies that achieved a 70% reduction in deforestation in the Amazon. And one of the signature policies of President Lula was a $1 billion, what was called the Amazon Fund, to finance activities to end deforestation. President Bolsonaro froze that fund, and environmental groups in Brazil brought a lawsuit based on the constitutional right to a healthy environment, arguing that it was a violation of that right to move backwards in terms of that particular policy in Brazil. The Supreme Court of Brazil agreed with that argument and ordered the government to begin to unlock, unfreeze the Amazon fund. And with the change of government, that is now happening. And President Lula has made commitments once again to end deforestation in Brazil. Similarly, this principle of non-regression has been applied in in Peru, where again, another lead smelter. And what happened here was the Peruvian government weakened the air quality standards for nitrogen oxides and sulfur dioxide. And that has been the subject of a case which was heard last fall by the Inter-American Court of Human Rights. A decision should be forthcoming anytime, and I am 99.9% sure that the Inter-American Court will find that that was a violation of human rights for Peru to have weakened their air quality standards. Healthy and sustainably produced food, another key element of the right to a healthy environment. And here we have countries like France. France recognized the right to a healthy environment in 2004 by adding it to their constitution, and subsequently became the first country in the world to ban all uses of the bee-killing neonicotinoid pesticides. France also passed a law, the first law passed by a northern nation, that prohibits the export of pesticides from France that are not registered for use in France. So those were both challenged by the pesticide industry and upheld by the courts, referring to the governments fulfilling their obligations related to the right to a healthy environment. And the first court case in the world to specifically mention the General Assembly resolution on the right to a healthy environment was a Costa Rican case where environmentalists sought to overturn the approval of a neonicotinoid pesticide. And the Constitutional Court of Costa Rica said the approval of that pesticide violates the right to a healthy environment. Another big threat in terms of healthy and sustainable food is the intensification of livestock production. And in a recent case in Mexico, there was a proposal for an industrial hog facility with 50,000 hogs. It was to be sited near a small community in the Yucatan Peninsula, near a small indigenous community. And that Mayan community brought a lawsuit seeking to prevent the construction of that industrial hog facility. And the Supreme Court of Mexico issued an injunction preventing it from going ahead because it would violate the right to a healthy environment. A safe climate, also a critical element of the right to a healthy environment. And we've seen countries where the right to a healthy environment recognized taking bold climate action. So Costa Rica, for example, which gets 99% of its electricity, by the way, from renewables, was the first country in the world to ban offshore oil and gas exploration and development, followed soon thereafter by Belize. And then France also passed a similar law. France also passed a law that banned, this headline's slightly misleading here, but it's such a nice picture. France passed a law that prohibited fracking for oil and gas, and then the industry challenged it, and the French court upheld the government's law, basically, once again, saying that because the government was acting to fulfill citizens' right to a healthy environment in a way that was consistent with the precautionary principle, which is also part of the French Constitution, that law was valid. So that's Costa Rica, France, Belize. And I did a country mission wearing my United Nations hat last year to Portugal. And we don't usually think of Portugal when we think of climate vulnerable nations, but it was really dramatic. I was there in late September. 60% of Portugal was experiencing a severe drought and 40% extreme drought. They are having terrible wildfires every year in Portugal. And last year in July, they had a heat wave that killed an estimated 1,000 people. So to the government of Portugal's credit, they are responding very aggressively by trying to follow the advice of the IPCC and move to a renewable energy-based future. So 5 years ago, Portugal got 40% of its electricity from renewables. In 2022, that number went to 60%. They expect to be at 80% by 2025. And in my report to the United Nations, I urged them to aim for 100% by 2030. In January of this year, they actually produced 88% of their electricity from renewables. So they're well on the way. And last week in Geneva, they said they accepted my recommendation to aim for 100% by 2030. So those are all stories of how the right to a healthy environment is a catalyst for action. This is the Supreme Court of the Netherlands, and this is a really important point to make, that the United Nations Framework Convention, Climate Change, the Convention on Biological Diversity, which are now over 30 years old, those international environmental laws contain absolutely no mechanisms for accountability, for ensuring that states comply with their commitments. So you can have a country like Canada that has set targets time and time again for reducing greenhouse gas emissions, never met a single one of those targets and not been held accountable. But when you bring human rights into the equation, alchemy happens, and human rights institutions and processes can be fused with environmental law that provides the substance to produce outcomes like the decision in the Urgenda case in the Supreme Court of the Netherlands, where citizens argued that the Dutch government's slow action on climate change violated their human rights. And the Supreme Court of the Netherlands, in this groundbreaking decision in 2019, said, yes, the right to life, the right to private and home life in the European Convention on Human Rights were being violated because the Dutch target of reducing emissions 20% by 2020 was not consistent with what the Intergovernmental Panel on Climate Change said was needed. So they ordered the government to reduce emissions 25% by 2020 instead. And as a result, the government of the Netherlands closed down 2 coal-fired power plants, lowered speed limits, put solar panels on the roofs of schools, and took a bunch of other actions. That decision has had ripple effects around the world. And in France, in Germany, in Belgium, in Canada, in the US, there are cases where people are arguing that based on their human rights, governments have to take more ambitious action. The right to a healthy environment is also being used as a shield to block coal development. So it was used successfully by a community in coastal Kenya to block what would have been the first coal-fired power plant in East Africa. And just on Monday of this week, the Supreme Court of Hawaii rejected a permit for a biomass plant in Hawaii that would have produced substantial greenhouse gas emissions because it violates the state constitution, and the Hawaiian state constitution includes the right to a healthy environment. So that's ripped from the headlines, folks. And the final aspect of the right to a healthy environment that I wanted to talk about today is healthy ecosystems and biodiversity. And the recent Kunming-Montreal Global Biodiversity Framework represents a radical change of perspective in terms of the relationship between conserving biodiversity and how we actually do that. It injects human rights into the very heart of conservation. If anybody wants to play Where's Waldo, look for the Canadian flag there. The Kunming-Montreal Global Biodiversity Framework says that all conservation action should follow a human rights-based approach. It highlights the rights of Indigenous peoples and local communities. It highlights the right to a clean, healthy, and sustainable environment. It highlights the rights of women and girls. And it really does mean that as we move forward, for example, towards protecting 30% of the Earth's land and waters by 2030, that we have to put human rights in the foreground. And of course, this has already been established as a successful way to protect biodiversity and respect human rights. In Namibia, they have community conservancies, which are run by local communities and have a terrific track record of great conservation outcomes, great social and economic outcomes. In Canada and Australia, we now have these flourishing Indigenous guardian programs. So taking a human rights-based approach to conservation is the most effective, efficient, and equitable way to protect biodiversity. And although there is not yet as much rights-based biodiversity litigation, we are seeing lawyers start to learn lessons from the climate context and apply it in the context of biodiversity. So this group of 25 children and teenagers in Colombia filed a lawsuit against their own government, arguing that deforestation in the Colombian portion of the Amazon watershed violates their constitutional right to a healthy environment. And the Supreme Court of Colombia said, yes, indeed, ordered the government to sit down with these young people and leading scientists and come up with a plan to end deforestation in the Amazon. Similar case in Mexico, where there was a proposal for a tourism development that required the destruction of a mangrove ecosystem. The Supreme Court of Mexico blocked that development from proceeding. And in a really interesting interpretation of the right to a healthy environment, which has been criticized by some academics as being anthropocentric, the Supreme Court of Mexico said the right to a healthy environment actually refers to both human health and ecosystem health. So really interpreting the right to a healthy environment in an ecocentric way. And the last benefit of approaching these challenges that we face through a human rights-based lens is that a human rights-based lens really focuses on vulnerable populations, such as Indigenous people. So this is me on a UN expedition to Norway, where I went north of the Arctic Circle and spent some time with the Sami people. Sami people's their economy and their culture are being devastated by climate change. They have been reindeer herders for thousands of years, but the changing weather patterns mean that reindeer, whose hoofs have evolved over thousands of years to scrape away snow to get at the mosses that sustain them, now they're getting ice and freezing rain in the winter, in even north of the Arctic Circle, and the reindeer hoofs cannot get through the ice. So Indigenous people have a great sense of humor. They made me wear like a space costume to go out on the land looking for reindeer, but it was a great experience. And another potentially vulnerable population is children. So on all of my UN missions, I try and meet with young people. Met with this great group of Fijian children who shared their hopes and dreams and fears with me. And I think it's another element of being the special rapporteur is working with the Committee on the Rights of the Child. So there's a UN treaty on children's rights, and the Committee on the Rights of the Child, which kind of the guardians of that treaty, is developing what's called a general comment on children's rights, the environment, and climate change. And they are working on that. I'm supporting them, and they are going to, for the first time, recognize that children have the right to live in a healthy environment. So there's a lot of good stuff happening around the world, and I think it's a real honor and a privilege to be serving in this role with the United Nations. And I look forward to your questions this afternoon. Thank you very much. Please. Great question. So the question is, how are these United Nations resolutions affecting action on the ground in British Columbia? And if I could expand that to Canada. So Canada there's 156 UN countries that recognize in law the right to a healthy environment. There are 37 that do not. Canada is currently among those 37. However, there is a bill before Parliament, which is called Bill S5. It's a bill to amend the Canadian Environmental Protection Act. It's gone through the Senate, and it's now at second reading in the House of Commons, and it will recognize that all of us have the right to live in a healthy environment. It's going to be a legislative right, not a constitutional right. So legally speaking, it's not as strong. And what that means in a province like British Columbia, because of Canada's antiquated constitution, is it's probably not going to have a huge impact. So there are other provinces and territories in Canada where the right to a healthy environment is recognized at the provincial or territorial level. All three of the Northern Territories have legislation in place. Ontario has a law in place, and Quebec has a law in place. So there was a proposal to create a British Columbia Environmental Bill of Rights back in the 1990s. It was drafted, but it ran into industry opposition. And frankly, that's the big problem in Canada, is that industry, whether it's the forest industry, the oil and gas industry, has way too much political power. And that's what's prevented us from moving forward on recognizing and implementing the right to a healthy environment. The industry here is terrified of Canadians having the right to a healthy environment because of what it might mean. So it's something that we should be advocating for at the provincial and federal level. And I think that there's a lot of older Canadian politicians who have scars from Meech Lake and the Charlottetown Accord, and changing Canada's constitution is unfortunately quite a cumbersome process. But now that Canada voted in New York in favor of the recognition of the right to a healthy environment. So I think we're on a trajectory where eventually our constitution, like the majority of constitutions, has to recognize Canadians' right to a healthy environment. And that'll be a game changer, because the Constitution of Canada applies to all levels of government action, unlike the Canadian Environmental Protection Act. At the back. Oh, that's a great question. So the question is, what are the main factors that need to be in place so that people can actually use their right to a healthy environment, for example, to bring lawsuits or to change the course of legislation? And there are a range of factors. The first thing I'll say is that the right to a healthy environment is not making much, if any, difference in countries that are governed by dictatorships or authoritarian governments. Got countries that are in a state of civil war, countries that are enduring extreme poverty. So there's some kind of bigger issues that impair progress on the right to a healthy environment. Those big issues impair progress on all human rights, though it's nothing unique to the right to a healthy environment. In terms of the factors that are really determinative in other states, partly it depends on the way that the right is recognized. So constitutional recognition is the strongest way to recognize the right to a healthy environment. It makes a difference the extent to which there's kind of a supportive legal ecosystem. So whether there are lawyers trained in human rights law, lawyers trained in international environmental law that have the capacity to bring these types of cases. Yeah, and so in Colombia, for example, there's a really strong community of lawyers who have this ability. There's organizations that exist to bring these types of cases on behalf of communities. And so that's been very positive in Colombia. Another really important factor, though, to consider is something called the rule of law. And that relates to the strength of government institutions, the lack of corruption, the independence of the judiciary. And where the rule of law is weak, you can get strong decisions from a court, but they don't actually lead to change on the ground. So for example, there was a decision in Nigeria a few years ago where, based on the right to a healthy environment, a court ordered Shell to stop flaring natural gas at its oil production facilities. That was 16 years ago, and Shell is still flaring natural gas because the government doesn't have the institutional strength to actually force Shell to do that. Well, the institutional strength or the political will, I would say. So those are some of the factors that are influential. Yeah, in the back, and then we'll come to you. Oh, sure. So the question is, what are United Nations country missions for special rapporteurs? Special rapporteurs are able to do 2 country missions per year during our term. The term of a special rapporteur is 3 years, and that can be renewed once. So I'm in my 5th year. Of course, the pandemic put a dent in my ability to do country visits, but we can request an invitation from any country in the world. So 193 countries. Some countries are not friendly to special rapporteurs and will not respond, or will just say no. So I did my first country mission to Fiji not because I wanted to go on a beach vacation, but because I wanted to visit a small island state that was outspoken about the climate crisis and see what were the actual conditions on the ground. And I can tell you it was absolutely devastating. I visited an indigenous community called Vunidangaloa. That was one of the first communities in the world to be relocated because of climate change. And they used to live in this idyllic waterfront village where they got all of their food from the ocean. They grew some crops on land, but because of rising sea levels, storm surges, saltwater contamination of their freshwater and their agricultural lands, they just couldn't live there anymore. So Fiji is a fairly mountainous archipelago, unlike some of the atoll nations. So they were able to move upland and inland by about 2.5 kilometers. Basically hack a new village out of the forest. They have better homes. They're close to a road, so they have better access to healthcare. But it's a 2.5 kilometer walk down a steep trail in blazing heat and humidity to get to the ocean. And so they've really lost that direct connection. And if you're an older person, if you're a pregnant woman, if you're a young child, you just can't get to the ocean anymore. So there are definitely human rights consequences of what's happened there. Fiji, 3 years before I went, had also been hit by Tropical Cyclone Winston, which destroyed tens of thousands of homes, caused incredible damage to farmland, miraculously killed very few people because it hit the less populated side of Fiji. But it was a multi-billion-dollar disaster, and so it was really interesting to learn about the the knock-on effects of that. These small island developing states that have to redirect money that would have been invested in education and healthcare and social services to rebuild basic infrastructure from these climate-related natural disasters. So that was my first visit. I went to Norway for my second visit because I wanted to go to the other end of the spectrum, a country that had gotten very wealthy from exploiting fossil fuels. Norway is at the forefront of many environmental issues. They get 99% of their electricity from renewables. They lead the world in the proportion of electric vehicle sales. Oslo is a beautiful city with a large area where there's very little traffic. Air quality is good. Everybody has access to drinking water and sanitation. But Norway is a major exporter of oil and gas, contributing to the climate crisis. So when I did my end of mission, at the end of each country mission, you release an interim assessment, hold a press conference, criticize the government, and then get on the next flight out of town. And I said that Norway needed to stop exploring for additional oil and gas, which they have continued to do. They needed to stop building new fossil fuel infrastructure, and they needed to come up with a just transition strategy to phase out of oil and gas. And as a result of those recommendations, I got death threats from people in Norway. So that was an interesting experience. After Norway, I went to St. Vincent and the Grenadines, another small island state. And I've been to Slovenia, Portugal. I'm going to Chile. I'm either going to go to Namibia or Senegal this fall. And then hopefully I've got permission from India to go to India next spring. I tried to get permission from China, but they refused to have me. So the idea is when you do these country visits, they're between 10 days and 2 weeks. So it's super intense. If you can imagine doing a trip to India in 2 weeks and trying to visit as many places, learn as much as you can, and produce a report in that time as well. The goal is to highlight the challenges that are being faced and also the good practices, so other states can learn from those, and then present a report to the UN Human Rights Council about that. Apparently we have no time left, but I'm happy to answer your question afterwards in an informal way. But thanks for your attention and for the good questions today.